The Young Thug YSL RICO trial had some important motions filed today from the state and defense. Brian Steele points out the hypocrisy in the Fulton County District Attorney's Office. Yeah, the state responds to the defense about evidentiary rulings, and then Doug Weinstein has one of the most legendary responses ever. He quotes so many people, it's funny as shit, so hit subscribe, here we go. Alright, first document we got right here is Mr. Williams' response to state's motion to restrict extrajudicial statements filed on 23rd, 2024. Motion to adopt motion for fair and constitutional trial on behalf of Mr. Stillwell, as well as Yacht Gotti's motion for mistrial, both filed on or about July 23rd. Notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge filed on or about July 23rd. Jesus. So very long. So Brian Steele, let's see what he says here. Response to the state's motion to stop them from speaking to the media. The state filed a motion to restrict extrajudicial statements. Mr. Williams' counsel statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection when the potential jurors were not fully charged to avoid all media reports concerning this indictment. So he's quoting attorney Fani Willis here, where she claimed her priority is to prosecute gangs. They are committing conservatively 75 to 80% of all violent crime we are seeing in the community, and so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia and you commit crimes, and certainly if those crimes are influence of a street gang, then you are going to become a target and a focus of the district attorney's office, and we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment, hopefully bring justice to a lot of the community who were victimized through the course you'll see in this indictment. But most important, the most important thing we're here to do is to keep the community safe, and we believe removing these 28 defendants will keep Fulton County safer. Willis said this on a podcast. I remember when we first took the office, we're screaming from the top of the hills that there's a gang problem. People were actually kind of treating us like we were crazy. There's a gang problem in LA, there's a gang problem in Chicago, but they did not want to admit that there was a gang problem in Atlanta. But we kept talking facts I knew to be true because I knew crime waves. I knew that one important person got killed and we got a gang war for several years. Brian Steele is just showing that Fani Willis also spoke publicly about this case a lot. He's calling out the state for being hypocrites, pretty much. Lawyer loves motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel which contains accurate factual assertions. Rule of Professional Responsibility 3.6, Comment 1 makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated those accused of crimes are guaranteed the rights to a public and speedy trial, there are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves. It also has a legitimate interest in the conduct of judicial proceedings, particularly in the matters of general public concern. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects relating to the character, credibility, and reputation or criminal record of a party, suspect in a criminal investigation or witness, identity of a witness, or the expected testimony of a party or witness, possibility of a plea agreement to the offense, or the existence or content of any confession, admission, or statement given by defendant or suspect, or that a person's refusal or failure to make a statement. What is more relevant to the issue at hand is the commentary relating to those subject areas more likely than not to have no material prejudicial effect on a proceeding. These subject areas include information contained in public record, the scheduling or resolve of any step in litigation. Okay? Every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. Specifically, Mr. Williams has repeatedly in public filings, as well as by and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The accused judge, Lawyer Love and Lawyer Hylton, have been accused of and found to have run afoul of their duties under the law, and Glanville has been recused and disqualified from his role as trial judge based on the motion brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. It's all on YouTube. Thus, the likelihood that Mr. Williams' counsel repetition of information in the public or in the findings of the court could materially prejudice adjudicative proceeding in the matter is absurd. Moreover, the jurors in this case have been provided cautionary instructions and admonitions countless times, at least daily over the 100 days, not to listen to anything related to the case. So unlike pretrial comments, which the state is guilty of making, Ryder. So Mr. Steele's points are actually very valid here. He's pointing out that the state's being hypocritical. How could these comments fuck up anything if they're already in the public record? There's no basis for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of materially prejudicing any adjudicative proceeding. Adopting Mr. Stillwell and Kendrick's motion for mistrial only if this honorable court finds that Mr. Williams was goaded into moving for mistrial based upon prosecutorial and judicial misconduct, and thus retrial is barred. Mr. Williams has been forced to remain in custody. The recused judge, I love how he keeps saying recused judge, just keep throwing out there that Glanville f***ed up. Lawyers Love and Hylton violated Mr. Williams' right to a fair trial, fair tribunal, right to due process, right to confront witnesses, and the like, causing Mr. Williams to be goaded into moving for mistrial. Talking about the ex parte meeting right here. Attorney Hylton unlawfully influenced Copeland to testify against Williams. Mr. Williams was prejudiced by being wrongly excluded from this critical stage of the proceeding. Lawyer Love and Hylton will be called as necessary witnesses in trial. as material conversations with sworn witness Copeland are not captured on the transcript. So Brian Steele is straight up saying that there's missing stuff. All right. Recused judge violated Mr. Williams' constitutional right to confront prosecutorial misconduct when lawyer Hylton introduced a known void, null, invalid, involuntary guilty plea before the jury. Lawyer Hylton elicited testimony from Detective Racy about an invalid, involuntary guilty plea, knowing that same does not exist under law to push the prosecution's invalid theme that Mr. Winfrey was protecting the supposed purported gang members now in the trial in the case at bar. The recused judge refused to permit undersigned counsel to confront Racy and prove that lawyer Hylton was eliciting non-factual and knowingly misleading testimony to the jury. This denied Mr. Williams his constitutional right to cross-examine witnesses. I don't exactly remember that whole situation, but I'm sure I watched it and it was just months ago. This trial is so long. Lawyer Love attempted to demonize counsel for Williams as well as others in front of the jury. This is Lawyer Love's standard practice. Brian Steele loves taking his jabs at Miss Love all the time. Prosecutorial misconduct has been perpetrated by Lawyer Love from the inception of this case in order to goad Mr. Williams into moving for a mistrial. I don't think that was intentional. She has that prosecutor attitude where they just kind of have a condescending tone about everything. But there's a substantial likelihood of a reversal by an appellate court if Williams is convicted wrongfully. This past month and a half alone, Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hylton and recused judge. This delay in causing this honorable court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this quote-unquote trial under the guiding hands of the recused judge, lawyers Love and Hylton. Another jab there from Brian Steele. The prosecutors and recused judge's misconduct and trampling of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials. After being goaded into same, this quote-unquote trial is not fit for a kangaroo. No reasonable person will argue that a speedy trial has been satisfied. Well, obviously. In what world does a state's case in chief take a year? The state has to present their case and it's going to take them a year. That means you just suck. Now he's complaining about how long the jury selection took because they went through 2,000 potential jurors for no reason. He's saying that is like not common at all. Like they actually only end up picking through 500 or something. Now he's talking about the inhumane conditions of the county jail. He's saying thugs on a flight risk right here. Furthermore, counts of this indictment failed to allege at least one essential element of the crime. Thus, there's a fatal variance and jeopardy has attached. Thus, this case can never be retried and should be dismissed at this time. The recused judge denied this timely filed plea and bar motion to dismiss, and then denied a certificate of immediate review, and thus the Honorable Court of Appeals of Georgia dismissed Mr. Williams' direct appeal. He asked this Honorable Court to grant blah blah blah. So yeah, another classic Brian Steele motion right there. Now we got some state's response here to defendant's motion in opposition for correct ruling on vague questions. Williams never provides authority that inquiring into vagaries classifies as a specific mode of cross-examination imparted by constitutional requirement. Even grounds that are constitutionally protected, however, may be subject to judicial controls. The Fifth Circuit has made it clear that ambiguous questions are not constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. Now she cites Rule of Evidence 611. Williams' motion attempts to constitutionalize an areas of cross-examination that is not so protected. Even assuming arguendo that vague and ambiguous questions were of the same stripe as an area like bias. Rules 401, 403, and 611A would preclude Williams' proposed inquiries. Alright. Williams' Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. This court has correctly sustained state's objections to defendant Williams' vague questions because such questions are an impediment to ascertainment of the truth. Jury proceedings shall be conducted to the extent practicable so as to prevent an inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or proffers of proof of asking questions in the hearing of the jury. Williams argues that the court's sustainment of objections for vague questions have curtailed defendant Williams' Sixth Amendment constitutional rights, but cites no legal authority for the proposition. So Ms. Law basically saying the defense is tripping about vague questions, okay? All defense have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state calls in the trial. The state will not object to cross-examination that is legally sanctioned. B, vague questions are improper. Defendant Williams' assertion that this court has incorrectly sustained objections to vague questions is incorrect. Repetitive proposed vague questions by Williams voice cluttered confusion on the jury, whereas unambiguous proper questions provide the jury with concise clarity of the facts and better equips them to ascertain the truth. And now she says the prior objections have been correctly sustained by this court to facilitate ascertainment of the truth. For example, Williams asked Atlanta Police Department Detective Belknap, do you know there are videos of countless performers or athletes there promoting their trade? State objected to this question because it was vague. The question was ambiguous because it is unclear what videos, which performers, and what trade the question referenced. Conclusion, Williams' assertion that his Sixth Amendment rights have been curtailed by the court's sustaining of state's objections to vague questions is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant, vague, and ambiguous questions during cross-examination. This court's prior evidentiary rulings in this matter have been in accord with the Georgia and federal constitutions and rules of evidence. Williams' motion should be denied. Like, I don't even remember the motion about this. State's response in opposition to defense motion for correct ruling on assuming facts not in evidence. Williams' Sixth Amendment right to effective cross-examination was not infringed by disallowing questions seeking to elicit facts not in evidence. We've heard that objection a lot from the state, probably hundreds of times, not even joking. Jury proceedings shall be conducted as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof, of asking questions in the hearing of the jury. There's Miss Love saying infamous added again. Williams asserts that the court's sustainment of objections for questions that assume facts not in evidence curtails the Sixth Amendment rights, but has no legal authority for that proposition. She said the same thing in the last response. She cites State v. Burns. All defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses. They're saying these objections to assuming facts not in evidence have been proper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considering information that is never properly admitted as evidence in the trial. In United States v. Almanzar, the court overturned a trial judge's decision to set aside a jury verdict based on insufficiency of the evidence because the district court assumed facts not in evidence and made unsupported assumptions. Williams' improper questions, which assume facts not in evidence, could confuse the jury. Williams says these objections are specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. So Miss Love once again is saying the defense is tripping. Who knows if she's right or not? I don't know, dude. I'm not a trial judge. So Williams asked Detective Belknap, do you realize that in Fulton County and in our county, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? To begin with, this question is predicated on a falsehood. So Miss Love saying they capping again. This line of questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants' lyrics in criminal trials. Williams' counsel asked Special Agent Racy if he knew that Dolly, defendant Williams' sister, was in a relationship with Jimmy Winfrey in 2015. Say objected because there had been no evidence that the two of them were in a relationship. Williams does not have a right to float unsupported and unsupportable distractions using sworn witness as the vehicle. Therefore, Williams' request to prohibit this court from sustaining any further objections to questions that assume facts not evidence should be rejected. So basically, Miss Love is saying they're capping, their Sixth Amendment rights are not being violated. To dumb that down. Now here's Doug Weinstein's official response to them trying to get lawyers to not speak to the media. Quote, everyone in favor of free speech, hardly a day passes without it being extolled. But some people's idea of it is that they are free to say what they like, but if anyone says anything back, that is an outrage. Sir Winston Churchill. Bro is not quoting Winston Churchill. That is so funny. Now he's quoting Fani Willis again from August 2022. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it. Which you do that for a form of intimidation and to further the gang and to not be held responsible. Quote, free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. Fried him, Doug Weinstein. This should not be surprising to anyone that has paid attention to the present case. Over the last 19 months, the state would apparently like the present case to be conducted in secret with proceedings happening in hidden chambers outside the prying eyes of the press and the public. Talking about how they don't want to show some witnesses for no reason. To paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them and they think it's hell. Bro was quoting all types of people. The state cites 3.6 Georgia Rules of Professional Conduct and cherry picks certain comments to support its motion. No case law is cited, no finely tuned order is proposed. As the state accurately quotes Rule 3.6, bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of kindred counsel that might be barred by Rule 3.6. I guess that is true. They pointed out the interviews, but not specific quotes from what they said. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by kindred counsel that might arguably violate the Rule 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by kindred counsel meets any of the elements of Rule 3.6. No argument that any statement made by kindred counsel was known to or should have been known to have a substantial likelihood of prejudicing the jury. The state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permit kindred counsel to speak speak in public on his behalf. Comment 5BA. Here we go. There are certain subjects which are more likely than not to have no prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record. And there you have it, boys. In their own ruling that they cited, it backfires on them. Each statement made by Kendrick's counsel relates to publicly available information. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take responsible steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies around him, and now by holding press conferences denouncing him in his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. Doug Weinstein knows how to write a response, boys. Like, just basically shitting on Miss Love and quoting like 5 different people. State's response in opposition to defendant's motion for correct ruling on self-serving hearsay. In accord with OCGA 24-8-801 and 802, this court correctly prohibited Williams from eliciting self-serving hearsay, self-quotation evidence. Williams has not made any offer of proof demonstrating that Williams can satisfy any hearsay exception applied, or that Williams is introducing this evidence for a non-hearsay purpose. Therefore, defendant Williams' out-of-court statements, whether classified as self-serving or as self-quotation, are inadmissible. The court has correctly sustained the state's objection to self-serving hearsay because Williams failed to address, much less overcome, his burden of proving a hearsay exception applied to his self-quoting statements. Williams asserts he primarily wants to introduce defendant Williams' lyrics and social media postings. Defendant Williams' self-quotation of his own lyrics and social media postings are inadmissible hearsay. State's response in opposition to defense motion for correct ruling on adoptive admissions. In evaluating whether evidence qualifies as a defendant's adoptive admission under Rule 801D2B, the trial court must find that 2 criteria are met. The statement was such that under the circumstances, an innocent defendant would normally be inducted to response, and 2, there are sufficient foundational facts from which the jury could infer that the defendant heard, understood, and acquiesced in the statement. And then they cite 3 cases: United States v. Hankton, Neal v. State, United States v. Carter. The trial court's prior evidentiary rulings on adoptive admissions have been in accord with Rule 801D2B and case law of the same. Williams' motion should be denied. So yeah, that's pretty much all the responses from today. Miss Love is saying the defense is tripping, and Doug Weinstein is dropping some good jabs. So is Brian Steele. So pretty interesting. Hit subscribe. Join the channel membership. It's only 10 cents per day. Love you guys. Thanks for the support. Peace out.